What if the rule the ATF used to scare you yesterday no longer gets a free pass in court today? That is exactly why the end of Chevron matters to you. If you miss this shift, you could still talk, search, and sign your way into a case you never had to hand them. Hit subscribe right now because what I'm about to show you could save your rights the next time a federal agent leans on a vague rule. Smash like now so you can find this again when you actually need it. You need to understand what just changed. The Supreme Court said judges do not have to automatically trust an agency's reading of a fuzzy law anymore. That means agencies like the ATF do not get the same easy win they used to chase in court. Let me show you exactly why that matters for your words, your home, your gun parts, and your paper trail. You're going to learn the sentence that forces the focus back onto the law Congress actually passed. You're going to learn the line that stops you from talking yourself into trouble. You're going to learn the words that block you from giving away consent for free, and you're going to see how one calm response can protect you while a lawyer does the real fighting later. If you think this is just lawyer talk, don't. This can hit you during a knock at your door, a phone call, a compliance visit, or a we just want to clear something up chat. Most people have no idea how fast a friendly contact turns into a written statement, a consent search, or a new problem. You think you're helping, you think you're being honest. You think if you did nothing wrong, talking will fix it. But when the rule itself is under attack, your mouth can become the evidence that carries the case farther than the rule ever could. Here's the reality. Even when agency power gets cut back, you can still hurt your own case in minutes if you don't know what to say. So let's set this up the right way. Before this Supreme Court shift, agencies had a bigger cushion when a law was unclear. If Congress wrote a messy law, courts often gave the agency room to fill in the blanks. After the Chevron ruling got overruled, that cushion got a lot thinner. Judges now use their own judgment. That sounds great for you, and in many ways it is, but a lot of people make the same bad mistake right here. They hear Chevron is dead and think that means they can argue on the porch, talk their way out, or ignore a visit. That is not how this works. You still stay calm, you still do not resist. You still do not lie. You still do not volunteer your life story. Your goal is simple. Protect your rights now, then let the legal challenge happen where it belongs. The first thing you do is force the conversation back to the exact law, not the agency's vibe. If an agent tells you a part, accessory, or setup is suddenly a problem, you do not start debating YouTube clips, internet comments, or what your buddy at the range said. You make them point to the actual law. Here's exactly what you say. Can you show me the exact law Congress passed that you say I violated? Word for word, memorize that line. That question matters because the biggest change after Chevron is this. Judges now decide what an unclear law means with their own judgment. They do not just shrug and say, well, the agency said so. In the Loper Bright case, the Supreme Court said judges must use independent judgment and may not defer to an agency just because the law is ambiguous. In plain English, fuzzy wording is no longer a free blank check. This comes straight from Supreme Court rulings. Now listen to what that does for you in real life. It does not turn your porch into a courtroom. It does not make the agent spin around and go home, but it does something very important. It stops you from accepting their version of the law as if it is already settled. You are making them show their work. You are putting the focus where it belongs on the statute, on Congress, on the words that were actually passed. Watch what happens when you don't do that. You start filling the silence. You say, I thought the ATF website said it was okay last year. Or, I changed it after the rule update, I think. Or, I bought it before the change. You think you are being helpful, but you are building a timeline for them. You are explaining knowledge, intent, and possession with your own mouth. Here's the trick they don't want you knowing. When the law is shaky, your statements can become stronger than the rule they are trying to lean on. Bad way, most drivers say I was just trying to follow the rules online. Then they hand over admissions they can never take back. Good way. Smart drivers say, can you show me the exact law Congress passed that you say I violated? Then the pressure shifts back onto the statute instead of your guesswork. There is also a second case you need in your head. In West Virginia, a Supreme Court basically said agencies need clear permission from Congress for huge power moves. In plain English, if an agency wants to make a big rule with major impact, it cannot just fish vague words out of an old law and call it authority. So when you ask for the exact law, you are not being cute. You are speaking the language the court is already using. That is why this question is so strong. It is short, it is calm, and it reminds everyone in the room that the agency is not the legislature. Keep it simple. Ask once, stay respectful. Do not start lecturing them about Supreme Court opinions. Do not say, you people lost Chevron. That is ego. Ego gets you nothing. Your goal is to create distance between you and the agency's claim, not win a debate on the spot. If they answer, great. If they do not answer, even better. You have already done your part by refusing to bless their reading with your own words. Have you ever seen someone talk themselves into trouble just trying to sound cooperative? Drop a comment below because this is where people give away the whole game. The second move is even more important because your silence only protects you if you actually use it the right way. A lot of people think staying quiet is enough. It is not always enough. In Salinas v. Texas, the court said silence by itself may not count as invoking your protection. That means you need to say the words out loud. Here's exactly what you say. I want a lawyer before I answer any questions. Then stop talking. Those exact words. You can also say, I am invoking my right to remain silent and I want a lawyer. If you want one line, use the first one. It is clean, it is direct, it is easy to remember when your heart is pounding. This is 100% legal. You are not obstructing. You are not being rude. You are not admitting guilt. You are using a right people fought hard to keep. This comes straight from Supreme Court rulings. Miranda v. Arizona is the famous case people know. That is the one that says you have the right to remain silent and ask for a lawyer in custodial questioning. But Salinas is the one people forget. Salinas teaches a brutal lesson. If you want the protection, you need to claim it clearly. So do not play cute. Do not smirk. Do not go half silent and half chatty. You speak once and then you shut it down. Why does this matter so much after Chevron? Because if an agency rule is weaker in court, the agency still has one old weapon that works great: your own statements. If you talk, they do not need to argue as hard about what the rule means. They can argue about what you knew, what you intended when you changed something, who told you what, and why you kept it. You may think you are clearing things up. You may actually be filling the holes in their case. Watch what happens when people miss this. They say, sure, I'll answer a few things. Then it turns into 20 minutes. Then they get asked when they bought something. Then they get asked whether they saw a rule update. Then they get asked why they kept using it. And now the whole story is theirs, not yours. A lawyer can fight the law. A lawyer cannot unsay your mouth. Bad way. Most drivers say, I don't mind answering a few questions. Then the interview keeps rolling and every answer opens another door. Good way. Smart drivers say, I want a lawyer before I answer any questions. Then the fishing trip gets a lot harder. You also need to understand tone. You do not snap it. You do not whisper it. You do not turn it into a speech. You say it like you are ordering water, calm, flat, final. If they keep pushing, you repeat it. If they act friendly, you repeat it. If they say they just need your side, you repeat it. If they say only guilty people ask for lawyers, you repeat it. Your job is not to convince them. Your job is to protect you. And here is the part people mess up. After saying the line, they start explaining why they want a lawyer. Big mistake. No extra words. No, because I didn't do anything wrong. No, because my cousin told me. No, because I'm confused. Just the line. Then silence. That silence is not weakness. That silence is control. The third move is where a lot of cases get super ugly because people give permission when nobody forced them to. If an agent asks to come in, look around, or just take a quick look, you do not say yes because you want to seem nice. Here's exactly what you say. I do not consent to any search. If it is your home, you can add, do you have a warrant? Those words matter. Say them clearly, then stop. Listen closely because this is critical. Refusing consent does not guarantee there will be no search. If they already have a warrant, or if they claim some exception, they may still move forward. But your job is not to solve that at the doorway. Your job is to make sure the search is not happening because you handed them permission for free. This is 100% legal. You are allowed to refuse consent. This comes straight from Supreme Court rulings. In Bumper v. North Carolina, the court said consent has to be truly voluntary. In plain English, a search is not magically okay just because somebody felt pushed into saying yes. And in Caniglia v. Strom, the court pushed back on warrantless home entry claims under a broad community caretaking idea. In plain English, the home still gets special protection. That means your front door is not the place to act casual. Bad way. Most drivers say, sure, come in, I've got nothing to hide. Then the search becomes something they agreed to, and that is brutal to undo later. Good way. Smart drivers say, I do not consent to any search. Do you have a warrant? Then they stop handing over extra permission the government did not already have. You need to hear this clearly because people confuse being polite with being open. You can be polite and still say no. You can be respectful and still protect your house. You can step outside and still refuse entry. You can comply physically and still refuse verbally. That balance is powerful. It keeps the temperature down while protecting your record. There is another reason this matters after Chevron. If a rule is being challenged, the government may want more facts, more objects, more photos, more statements, and more context to hold the case together. Your consent can hand them all of that. So never help them leap over the weak parts. Keep your answer clean. I do not consent to any search, then wait. 90% of viewers do not stay long enough to learn this part. If you're still here, you're serious about protecting your rights. Show me by hitting that like button because the next move ties the whole thing together. The fourth move is simple, but it is deadly effective because it cuts off the pressure to just handle this right now. If they want documents, clarification, or some statement about what you own or changed, do not start digging through drawers or your phone while they stand there. Here's exactly what you say. Please put that request in writing and send it to my lawyer. That line buys you space, slows the rush, and keeps you from making stupid mistakes under stress. Why does that matter? Because agencies change positions. They issue letters, they rewrite guidance, they reinterpret words. In Garland versus Cargill, the Supreme Court said the ATF exceeded its statutory authority with the bump stock rule. In plain English, the agency changed its position, tried to fit bump stocks into the machine gun law, and the court rejected that reading. So you should never assume the agency's current view is the same as the final legal answer. This comes straight from Supreme Court rulings. Bad way, most drivers say, hold on, I'll grab the paperwork and show you everything. Then they create a roadmap, hand over context, and lose control of the contact. Good way. Smart drivers say, please put that request in writing and send it to my lawyer. Then the rush stops and the response gets handled with a cooler head. Here's the reality. Written requests are slower, cleaner, and easier to review. Your lawyer can compare the request to the statute, the rule, and the cases. Your lawyer can decide what must be given, what should be challenged, and what should never be volunteered. You cannot do that well while standing in your socks at the front door with your pulse going crazy, so don't try. You protect you first. Then legal strategy comes after. Now step back and look at the frame. Loper Bright says judges use their own judgment on the law. West Virginia v. EPA says agencies need clear authority for major power moves. Garland v. Cargill says the ATF cannot stretch a statute past what the words really cover just because it wants a result. Salinas says if you want silence to protect you, you need to claim it clearly. Bumper and Caniglia remind you that consent and home searches still matter in a huge way. In 7th grade English, here is what that means for you. Agencies got less room to make up the meaning of fuzzy laws. Judges got more power to say what the law means. But none of that helps you if you hand over admissions, consent, and evidence before your lawyer ever touches the case. The court fight happens later. Your part happens first. Your part is short lines, calm voice, no arguments, no consent, and no volunteering. So the legal map is actually simple. Loper Bright helps on law, Cargill helps on overreach, West Virginia helps on major power grabs. Salinas helps you understand why you must speak to claim silence. Bumper and Caniglia help you understand why your door and your consent still matter. That is the whole game. Less agency deference does not mean no danger. It means the battlefield changed and you need to act like it. Let me show you exactly how this plays out in a real situation. Imagine you're at home and two agents knock. They say they want to ask about an accessory, a rule change, or a purchase record tied to your name. You open the door and they sound calm. One of them says they just want to clear up confusion. The wrong move is what most people do. You invite them in, you start talking, you say you saw different things online, you explain when you bought it, you tell them what you changed. You offer to show them where it is. Watch what happens. A 5-minute chat becomes a statement. A quick peek becomes consent. A vague rule becomes a much easier case because you helped build it. Now the right way. You step outside if you choose, and you keep the door behind you. You stay calm. You do not argue. You do not get cute. First, if they claim you broke some rule, you say, can you show me the exact law Congress passed that you say I violated? If they start asking questions, you say, I want a lawyer before I answer any questions. If they ask to come in or look around, you say, I do not consent to any search. Do you have a warrant? If they want papers or some follow-up, you say, please put that request in writing and send it to my lawyer. That is it. No speech, no debate, no internet lawyer energy, just clean lines. You are not trying to win in that moment. You are trying not to lose in that moment. That difference changes everything. Agencies may still push, they may still posture, they may still come back with paperwork. But now the matter moves on to legal ground instead of emotional ground. And that is where the post-Chevron world helps you most. In my next video, I'm breaking down what to say when an agent asks to come inside for just 5 minutes. Subscribe right now so you don't miss it, because that one mistake wrecks people faster than almost anything else. So lock these points into your head. If they claim you violated a rule, ask for the exact law Congress passed. If they want answers, ask for a lawyer before you say anything else. If they want a search, do not consent and ask if they have a warrant. If they want documents or details, make them put it in writing and send it to your lawyer. That is your power now. The end of Chevron did not end agency pressure. It just gave you a better legal field to fight on if you stopped giving away free ammo. Hit subscribe so you catch that next video on doorway consent and 5-minute talks. Smash like if this helped you see how the ATF game just changed after Chevron. And drop a comment telling me which line you're going to memorize first. Stay sharp, stay calm, and protect your rights.